Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, criminal court, and other court issues, as well as CPS. I am your host, Maryann Petri. You can find me, my books, and blogs on dismantlingfamilycourtcorruption.com. You can find the books on Amazon as well, and they are in audio. Raised by These Wolves Volume 3 will be coming out sometime in January. I have a return guest. I'm really happy to have Marc Fishman back on. And we're going to talk about that. He was recently on We're Not Stumped podcast on YouTube, which is hosted by Mike Bolland. And he talked about how New York State has ignored 5533B, which was installed in 2015, that if you're hard of hearing, the court has to give you accommodations, and they're not doing that. And I am very happy to have you on, Marc, because we were also talking about this issue, which is protectnewyorkers.com, and we encourage everyone to go in and sign it, please. So I welcome you, Marc.
Thank you, Maryann. It's always nice to be on your podcast, and thank you for your advocacy and your dedication and hosting this. It's such an important forum. You know, it's so important to educate others so that they don't have to repeat the suffering you and I have gone through for years and not seeing our kids and battling over and over in state and federal court.
Oh, exactly. A lot of people didn't know, like I didn't know back in 2015 about ADA accommodations, had I known, but no one was talking about it. Now we're all talking about it.
Yeah, it's amazing. You know, like after losing for 2 years in family court, you know, and this was back in 2013, 15, where some of my friends, had a divorce or had a family court matter where, each party won half the time. I started losing time after time, and had issues where, I wasn't able to hear in the courtroom with my tinnitus and my TMJ and occipital neuralgia. I wasn't registering. I couldn't write and take my own notes because I have cubital tunnel syndrome, in addition to carpal. For those of you who talk about cubital tunnel syndrome, it's when your nerves weaken in the elbows. And I had surgery in my elbows to regain function in my lower two fingers, so I couldn't hold the pen. So back then, Maryann, when we're denied an iPad, we're denied a tape recorder, we're denied an aide to come to courtroom because, oh, you can't bring anyone in because, oh, courtrooms aren't open to the public. Oh, but Your Honor, the outside of the courtroom says, open to the public. Oh, yeah, but it's not. This is private, but Your Honor, my ex can bring all her advocates from all these nonprofits, women agencies, and I can't bring anyone in. No, you can't, but I need an aide. I have a prescription for it. I don't care. Take your own notes. But Your Honor, I can't order from a stenographer. There's no stenographer here in family court in New York. We don't have them. So what, Mr. Fisher? You have those two hands. Yeah, the hands that are numb, Your Honor. Nerve injury.
Right.
Mr. Fisher, you look fine. You can take your own notes. You can order transcripts like everyone else. Back then, Maryann, order transcripts. Some of my transcripts took 14 months. Because digital or analog, you have to find it. You have to send it to a transcriber who then couldn't hear it. Because the other thing you and I discussed is that in Westchester County, you have three courtrooms, three family courtrooms. The only county in New York State, Maryann, that has three family courts. Okay, so we have New Rochelle, Yonkers, and White Plains, right? So sometimes I'd actually have court in all three with different judges. They really taught you my mobility disability. You couldn't get to all, and they'd say, why are you late for the second, third? I said, why do you have me in three different courthouses? How do you expect me to get here? You have no accessible parking outside. And I have mobility issues with an aide. You think I can just climb up, So they're very archaic and they're very antiquated. But the point I wanted to emphasize to you in terms of the courtrooms is that back then, the court administration in 2015 had an audit, and it said that Yonkers and New Rochelle courthouses were quote unquote, Maryann, inaudible. Can you imagine that? They're inaudible to the regular ear, non-disabled, because they're in office buildings or antiquated buildings where there's an echo. It's so loud. You have people outside. They weren't set up as courthouses. It's inaudible according to OCA standards. Wait a second. If it's inaudible to OCA standards, don't expect me to hear with tinnitus ring in the ear and a occipital neuralgia stimulator near my left ear and TMJ and aches and pains. Don't expect me to hear. My stimulator is going on and off. And the cruelty is that, oh, so what, Mr. Fishman? Who cares you here or not? You got an attorney, you know, as you and I said, it's cruel and unusual punishment. You don't have communication in a courtroom. How are you supposed to win? And that was what you and I have discussed year over year. They didn't want you to. They just wanted to humiliate you for your disability. And I say you're not going to win. What's your fault? I was hit by a van. They was speeding, doing 45 miles per hour in a downhill by a school, and I was in a stationary car on a drop-off line at 7:30 a.m. on June 10th, 13. What did I do wrong? What did my kids do
Oh,
wrong? Okay, and so as you and I discussed, New York, we found out because again, it wasn't very publicized. The signage back then to show that they offered accommodations. So Governor Cuomo, 2015,
mhm.
signed a law called S as in Sam 5533B. S 5533B. 2 pages. I love short laws.
Yeah,
Don't you
me
love
too.
short laws? Because a couple paragraphs. So basically, what it said: if you are deaf or hard of hearing, you can request an interpreter, or you can request real-time transcription with the acronym called CART, closed area streaming transcription, something that it does. Closed area real-time transcription, people call it. And CART actually gives you a transcript when you have it in most courtrooms. New York State won't give you a transcript. New York State's like, no, you got to order a transcript, but we'll display the letters on a computer screen near where you sit in a courtroom or virtually, like in the captioning you have right now on Zoom.
Mhm.
And so for those of us who register better reading the words, seeing the words, than hearing them because we don't always hear it's noisy or it echoes in our ear, or in my case, a stimulator power cord running within centimeters of my left ear, going numb all the time.
Mm.
It's basic communication, particularly when you're in a courtroom all day for like 9 hours.
Oh,
My left ear goes numb. My left side of my face goes numb. I've had surgery to remove a TMJ, ball joint infection, parotid mass, ear surgery, jaw surgery. It's numb. So so that kind of thing is cruel. Is that you had to learn, right? Laws. You had to learn that these accommodations were available, and then once you asked for them, as I asked for them through Judge Michelle Schauer, the terrorizing, disability discriminating judge who
yeah.
still tortures many in White Plains,
Oh,
formerly in Newark, Shell, and Yonkers, right? As well as Nancy Barry, the head of court administration, who both said very eloquent in their report, Mr. Fishman, your tinnitus disability does not prohibit you from hearing in any way. You can take your own notes. You can ask the judge to pause, okay? But tinnitus is not a hearing disability. And then
oh,
you say
so
to
they're
them,
doctors now. Isn't that amazing?
you said it. That's the next question. Do you have any medical history? Did you study biology? Are you a nurse? Are you a doctor? And, the judge thought that was insulting. And, insulting, Your Honor? You're denying an accommodation. You expect me to understand. I know you let me sit in the courtroom very close to you, so I can read your lips most of the time. But, we're talking about witnesses that come in. We're talking about 3 sets of attorneys for my ex-wife, all these witnesses, noise in the courtroom, the bailiff moving around, the court officers. I hear all these sensitive sounds. We're in a room without windows, echo, 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 and you don't care. And the judge would just say, well, court administration said, I don't have to give you the accommodation. So they said it, I don't have to give it to you. And that's what led to, what you've had me on now, I think 6 times so graciously, is the infamous
Mhm.
federal lawsuit where we sued New York State not only to enforce S5533B, to get communication accommodations, but also to say that the judges have no immunity, administrative immunity. Yeah, I want to emphasize administrative immunity. They're denying access to a courtroom. You're basically saying that my disability isn't a hearing disability when tinnitus is the most common filed disability for veterans in Afghanistan and Iraq.
Mm.
Most common one on the VA. Most common one, meaning most veterans who were in those wars qualify for disability benefits through the VA and through Social Security based on tinnitus. But in Judge Schauer's courtroom, tinnitus is not a disability, and Mark isn't hearing impaired enough.
Oh my gosh.
Right? Enough. What does enough mean? Right?
Well, I noticed even when I was in, I guess you want to call it child support court, you would give the judge physician verification forms We call them PVFs here in Pennsylvania. She would ignore them. She ignored the migraines. She ignored the back issues. I had a rundown of problems that she just chose to ignore. And I don't know, had I known to invoke the ADA rights, I don't know if that would have even made a difference with her because I think she had a personal vendetta along with the opposing attorney. Would
So
you know?
sorry you went through that. As I
Well,
said, I had hired Donna Drum. Actually, I was on LinkedIn and I did a search. And forgive my French, but I was so frustrated on LinkedIn that I said, um, Judge Schauer is a bitch under
yeah.
the ADA. And Donna Drum's name came up consultant for ADA public accommodations. Like, what are you searching in 2015, 16? When you're trying to understand who's going to help you. And she said she ended up attending a lot of those court hearings, writing the accommodations, wrote it very specifically, in a $3,000 report, 11 pages, how these disabilities of post-concussion memory, tinnitus hearing, occipital neuralgia, burning eyes, numbness in the left head and rear, numbness in left ear, um, cubital tunnel syndrome, cannot write his own notes, mobility with the peripheral neuropathy, okay, rehab 4 hours a day, 6 days a week, can't be in a quorum, and memorialize this in writing in a way that you have like the Albert Einstein of disability advocates to Judge Schauer and to Nancy Berry, and then to get a response back: denied, 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 everything denied. Oh, but Donna Drum, you could sit next to him in the courtroom. Oh, his request for a note taker is denied. Wait a second. Oh, the court administration said I could have a note taker, but Judge Schauer denied me access for note taker in the courtroom. Okay, I can't take my own notes. The attorneys are arguing law. My AD advocate is trying to help me interpret and objecting every time the judge says some monster accusation about my disability or insults me. Who's going to take notes? Who can take his own notes? He can order a transcript like everyone else.
Right. I think there was a personal vendetta on you too. You were the target parent.
Sure. Judge Schauer would say over and over again, and especially at the hearing to jail me,
Oh,
on June 27th of 2017, she said, Mr. Fishman, your claim of memory impairment and hearing impairment belies the record. You hear and you remember when you want to. And my advocate would stand up and say, Your Honor, have you read the neuropsych reports, which is the gold standard of reports for, post-concussion syndrome? Someone has a long-term concussion over 6 months symptoms. She said, yeah. She said, yeah. And I said, well, can we bring the doctor in to explain it to you, to answer any questions? Because you're acting like his failure to remember or hear is his fault. When you've denied him accommodation since I've been in this case now for a year and a half, it's cruel. What you're doing is cruel and unusual. He can't hear. Donna, you could take notes from him. You could explain it to him. He's a monster. Why are you representing him? You can't talk to him that way. What's this all about? And then Donna Point said, look at his ex-wife. We're seeing over here like 9 interns from Legal Service Hudson Valley. Mark wants to bring in one note taker, and you and your court attorney block the note taker from entry. He has an order here from court administration that no taker can come in, but you block it. And then OCA says, well, we can't control what Judge Schauer does. Appeal her. We tried to appeal her, Maryann. Went all the way to the Supreme Court. No one takes the appeal. The second department says, you didn't prove you're disabled. You're right. I didn't. My doctors did. My AD advocate did. My surgeons did. My implant neurosurgeon. The testing Your Honor did with 19 reports: psychological, neuropsych, social worker, psychiatric, hearing impairment, hearing impairment, hearing impairment, memory impairment, hearing impairment, writing impairment. And Judge Schauer says, I don't care what any of those reports say. I don't have to use any of this, Fishman. I don't have to have any of those people testify. You are too smart to tell me you don't hear and you remember. 3 weeks in jail, leg irons, 8 officers seizing on me, go to the pen. And the nightmare of June 27, 17 still haunts me today,
mhm.
over 8.5 years later, of the consequences of not being able to hear and remember at that meeting, that court appearance, where she issued an order of protection verbally, and I couldn't hear it. But the one I got on the transcript said that my order of protection is subject to supervised visitation. Yet when I was arrested with a $500 a day supervisor and my disability aid,
Mm-hmm.
Okay, a year uh, later, right? The police said, no, there's a full stay away given to you June 27th, 17. And to suffer because I couldn't hear and register, a note taker was blocked.
Mm-hmm.
And to find out in testimony, oh, yeah, Mr. Fishman never got that order in writing, but his ex-wife did. His ex-wife's attorney did. His ADA advocate never got it. His attorney never got it. He never got it. But the judge told him, stay away from the house. Yet in the family court appeal, Maryann, it said from the judges, after I was convicted at a trial of violating an unserved order of protection, right? Okay? Convicted of violating unserved, one I never got, for going near a property on supervised visitation. Okay? The written copy that was produced in court said I was served. It also said there's no distance to stay away from that property on the order of protection, meaning most orders of protection stay 100 feet, 200 feet, 500 feet, 2,500 feet, nothing. So on the appeal of that order, which came out a month after I was convicted in criminal court, right? The appellate division interpreted Mr. Fishman is to stay away from the home, the work, and the school, except EXCEPT, except limited supervised visitation. Yeah, twice a month, 2 Saturdays. I was resting on a Saturday with the supervisor. By the way, didn't go on the property, didn't talk to my ex, was 4
Nope.
houses away. And you're convicted of completed violation of order of protection when you can't be guilty of completed. You didn't go on a property. The order they produced didn't. And then you find out, because at the same time I'm suing the cops
Yep.
for denying me my aid,
Mm-hmm.
denying me real-time transcription, denying me my notes, denying my records, and not interpreting the 30-page order, which had this order of protection saying subject to visitation, not reading it. We're convicted, later finding out that there was a third page to the order of protection that said party not served. But the jury only got the first two. And where did we get it? Federal court. And then began the cycle of motions to dismiss, reverse the conviction, which is we're still fighting today, unable to reverse it.
Do you wonder, is there going to be justice? Are they going to come through at some point?
There is justice because we spread awareness and make it easier for others to get a note taker in cart, then no one else has to suffer in jail the way you and I did. That's the justice. For my kids and I, it's torture. I haven't seen my kids since February 27, 21. I know you haven't seen your kids. How long? Right?
Well, I mean, it was up until the boys 2024, but then I have not heard a peep from them really since last summer. But the oldest one, that was in 2014.
Isn't that horrible?
It's all brainwashing. It's all well done brainwashing and the purchasing of expensive items.
It's horrible.
Yeah.
I'm so sorry you had to endure that.
Oh, thank
With no
you.
words.
Well, you too.
Well, in my case, they've had orders of protection. So there is no ability to try and do anything because they want to upgrade your misdemeanor to a felony. And those like me know that the system's so rigged.
Yes.
The only way you're going to get justice is federal court publicity and changing laws that you no longer play their game. I relocated other side of the country. I fight in federal court from here. Okay, I do my rehab from here in California. And like you're saying, you know, it's totally an unfair form. Luckily, now I'm happy to report, you know, we have made some change. My attorney, Kaner Demiriak, who has multiple sclerosis, settled his lawsuit after he had a Supreme Court certiorari hearing. And New York State posted signage. In most judges' desks, they have a picture of an ear in New York with a finger pointing if you have a problem, you know, at the ear. Tell a court officer. Or when you go to a court clerk, this is available. And make it easier. Better signage. Okay, those took litigation from him. That was a stipulation in his lawsuit. And he's not even hearing impaired. In my case, my order of July 16, 21, ordering communication accommodation, I just say broad, you know, basically means everyone could bring a note taker to the courtroom who has a hearing impairment or a memory impairment. Everyone could bring an iPad, record. Everyone could bring a transcriber, bring someone in shorthand to record for them. You know, we don't have video cameras yet in the courtroom, but I think it's only a matter of time, Maryann.
Mm-hmm.
So at least many others have not had to suffer the same way of actually being jailed. And as you and I discussed all along, I was in a jail hospital because the warden said you're disabled. It's the only place I can accommodate your disabilities. You have a remote control for your stimulator on your right and left. You know, if someone strangles me with the remote control at night, I'm dead.
Oh,
If I don't charge myself, I get a massive headache and get bloodshot eyes and red rashes. So obviously, wait a second, the warden in Westchester County Jail thought I was disabled after just doing an intake and getting letters from all these doctors and advocates. But Judge Schauer, who had me for 49 months, and got 19 reports of specialists in the appellate directory of Hutch using that I paid for like a horse's ass, trying
mm-hmm.
to appease a judge who was never going to be appeased, period, telling him I'm hearing and memory impaired, mobility impaired. And I don't have to go by those. I don't have to let any of those people testify. I don't have to read any of the reports. We let them in as evidence, but let the record show that Mr. Fishman's claim that he doesn't remember belies the record. And then she gives an example. She said, last week you testified. You took your twins, who were 3.5 years old, to Epcot. And you're telling me how Aiden is having fun with the miso soup in 3 bowls, mixing it for himself and for his brothers. You're telling me how Sky takes the chopstick and stabs the avocado roll and holds it up like a marshmallow. And you're telling me this about 2 years ago, Mr. Fishman, about what happened to you 2 years ago. But when I asked you why you were 5 minutes late dropping the cuts off last Thursday, you smile and you say you don't remember. That belies the record. And then Donna Drum would stand up my advocate and say, no, it doesn't. Read the report. Short-term memory. Short-term memory, Your Honor. Wexler test scores. Donna, why are you representing that monster? He just lies. He can't remember. If he remembers the Epcot 2 years ago, he should remember why he was late 2 weeks ago. Your Honor, it doesn't work that way.
No.
Everyone's concussion's different. I don't care. 2 weeks in jail. Officers seize him.
Ugh.
Seize me? Seize me? What? Oh, you violated order of protection. You sent the kids gifts, and I told you there was no gift giving. He said, what are you talking about? You gave me these orders of protection that said I could send gifts on major holidays. Those weren't holidays, Mr. Fisher. Go to jail. Ridiculous. 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 This is what they want to find something wrong. They want to put an order of protection so you violate. They want to send you to jail, like in your case. Am I wrong?
Right. You're correct.
So then you say to yourself, this isn't a fight in a forum. But then when you bring it to federal and you say that Judge Schauer gets served, along with 5 other judges who I had immediately after her, and they get served by U.S. Marshals because the judge named Ken Karras, approved by the U.S. Senate, majority U.S. Senate, says there is probable cause discrimination. You knew he was disabled. You had more than enough reports. You're saying tinnitus is not a disability, yet he's I believe, a veteran. And of course, in the veteran world, where most concussions were near an IED or an explosion or a tank in Iraq or Afghanistan, of course, tinnitus was a disability. Matter of fact, it came out years later, Maryann, that the earplugs the Army gave were defective from 3M, so that they created the tinnitus as opposed to doing any repellent ear damage. So you have millions and millions, right, affected by this in private lawsuits and public class actions about tinnitus. No, Mr. Fishman hears when he wants to. Mr. Fishman remembers when he wants to. Mr. Fishman makes a mockery of this court. And, she said, Donna, I want to say this to you. You were an associate with David Bowie's law firm, who defended Al Gore in the Supreme Court on the butterfly ballots, the 2020 election. How dare you represent a person like this, a monster? He's making a mockery of this whole proceeding and saying that everything it needs to be accommodated and that his disability affects his ability to communicate everything. That's just horrible. And Don would stand up and say, Your Honor, I would not represent Mr. Fisher if he wasn't disabled. And the only one making a mockery here is you. You're insulting a man who's disabled. Your own reports show he's disabled, and you're throwing him in jail because he's disabled. And then you're chastising me, another attorney, member of the bar, former head of the Women's Bar Association in Westchester, questioning me that I'm representing him as a monster because you say he doesn't look disabled. Well, Your Honor, what does disability look like? Because I don't see that in law S5533B, which says if you're hard of hearing, you get an accommodation. And Your Honor, all you have to do is flick the switch The computer screen goes on your wall, and he can get this accommodation, and you don't want to. Miss Drum, why do you represent a monster like him? Shame on you. Shame on her. What did she do? Shame on her. And Judge Schauer still wears a robe, gets a pension.
That's disgusting.
Sure is.
I think these judges I think they hear what they want to hear. They just do what they want to do. They're running the courtroom the way they want to, and they really, don't want to hear about the Constitution, and they just trample all over the people they know they can. And like here you are sitting there trying to figure out what the opposing attorney, I can't imagine what that was like. You're trying to figure out what they're saying while you can't hear right. That's that in itself is scary on top of being in family court, which is also a disability. I mean, it's like I've heard that as soon as you walk into the family courtroom, it's a disability. You're already traumatized.
You said it. I don't know one person who's gone through family court, win or lose, because it's all losing. Just the
Right.
fact of going there is unnerving, stressful.
Oh, yeah.
You have a chance to lose your kids, lose your savings, lose your work, lose everything.
Yep.
Okay. I don't know one person who doesn't get depressed or anxious or can't sleep. It is disabling. Why should it be disabling? Why should you have a process that is disabling in nature? And you keep someone there for years? I mean, one of the reasons I went to federal court, Maryann, wasn't just that Schauer jailed me. I mean, the warden reduced it a week. It was 2 weeks. And again, I felt fortunate. I was in a jail hospital. I had a nurse. I wasn't fortunate in that I didn't have a pillow, put holes in my head, and fell when I got out. But I was fortunate that I was kept safe and that the nurse was looking at the camera 24/7. And we found out years later, writing a report every 3 hours of everything I did. Every time I activated a stimulator, every time I went to the bathroom, every time I paced, every time I turned red. I mean, and then on every piece of paper, it says hearing impaired, can't hear, hard of hearing, alerting the future nurses because they had shift changes, learning a
Right.
doctor, and keep in mind, they knew how sensitive my implants were because I had a card that said, don't go through the metal detectors. Anyone who's been through jail knows the metal detectors are much stronger radiation, much stronger x-rays. And in my case, dangerous for the implants in each chest because it heats it up.
Mm.
So if it heats it up, you could get electrocuted to die. So don't go near the metal detectors, which are in every section as you go from, let's say, visitation or to a doctor's offices. So I had escorts.
Mm-hmm.
And to tell the other guards, he's not going through the metal detector. We don't want an explosion. His explosion could hurt him, kill him, but it could really hurt someone else too who's next to him. And so you had a warden who didn't want me there. I was in holding for 14 and a half hours with no food or water on the 27th. You know why, Maryann? Because that warden was fighting with Judge Schauer saying, I want to take him to a hospital. I want to release him. I cannot jeopardize his safety. What about the safety of the other people with him? He's got two explosives in each chest,
Mm-hmm.
and we can't shut him off. Two neurostimulators, and you want me to keep him in a jail with 1,200 inmates? You want me to keep an explosion because he sent gifts to his kids, and you said it wasn't a major holiday? Are you nuts? It's not even a criminal charge here. And guess what? Yep, they kept me there. At 1 a.m., my aide brought the remote control for the sleep apnea stimulator, the tongue stimulator, the hypoglossal that pushed out my tongue. At 1 a.m., I got to the jail. It was before noon,
Mm.
right? I mean, so you want to talk about torture, total torture. And I couldn't adjust the stimulator. It was on a high setting, needed to lower it. It already done damage to the rear of my head,
Oh.
put some holes and headaches. And then you're there, like, there's no pillow. We can't give you a pillow because the pillow's got to have a pillowcase. And you can't have because we're fearful you'll commit suicide and strangle yourself, suffocate yourself, or someone else in the hospital. What are you talking about? What do people use for a pillow? Well, in the normal jail, you have a bump in the bed. You have a bump in the bed, so you have an element. And where you're in a hospital bed, so best we can do is give you a blanket, roll it. That's not going to do it for this. Well, we can't do anything. So you want to torture me for 2 weeks, not having that. You're going to keep me safe because, you have guards and nurses looking 24/7 with cameras and stuff. And but the first 2 days, you wouldn't even give me my remote, so I couldn't even adjust the pain stimulator. It already done its damage. So, the torture was that here in Judge Schauer's case, you're making me relive a traumatic accident I had June 10th, 2013. June 10th, 2013 was ran by a van. And 24 surgeries since, 8 implants. You're making me relive this. And that's when I decided, I can't hide behind the curtain and have to go public in federal court, sue, and expose my numerous disabilities, because when you then, what are you going to do then? We'd come back out, the judge would, like you said, make more false charges, more accusations up, and more situations where she won't accommodate your disability, mock you for not remembering a hearing. Wait a second, you had to change the form. As you and I said, family court, most people just lose. So what did you have to do? Sue in federal court. The first of a couple lawsuits. What else were you going to do? On the ADA, Rehabilitation Act, and also state court S5533B.
And they don't enforce that. People are passing bills. They're not being enforced. I think, I don't know how people are going to think of this, but I think the judiciary needs to be cleaned out. They need to clean house. I think the FBI needs to go in there to every courthouse and clean house, because there's too many connections and they're not following these laws or the Constitution.
You're correct. Under the 2010 amendments to the ADA, most people are aware that George Bush Sr. signed the American Disabilities Act, I believe, in the early 90s, for accommodation for disabled. So then, Maryann, you had all this litigation from like 1991 when he signed the law through 2008, through the last month of his son's term. His son, in January, I believe it was 2008, or January 2009, correct me, January 2009, signed the amended ADA. Were you aware the American Disabilities Act was amended? It's ADAA, amended ADA. Mm-hmm. It was signed with the Anita Wolf law, the one where she had sexual harassment from Clarence Thomas and anti-sexual. It's in the same law. So everyone knows that portion of law, but no one knows this one. So what this said was proof of disability is minimal. And instead of having rulings between 92 and 2008, it said, oh, you're 67.15% disabled because you have one arm, you don't have the other. Or you're 87.2% disabled because you lost a finger. You know what? You're 15% disabled because you don't have feeling of, what is it? It's ridiculous. It said that proof of disability is minimal. A disability is disability. It can be invisible, it can be emotional, it can be disabled, and you look at it as disability and receive the same accommodations, for a qualified, regarded, acknowledged disability. So it took away all the lawsuits where the courts are ruling, saying you're percentage disabled here, percentage disabled there. So, but as you said, state courts, many of them, like the appellate division in Brooklyn, utilize the old standard. Oh, you're not disabled, Mr. Fishman. I'm not disabled. They've sent in 4 decisions. I'm not disabled. None of them are doctors. You're not disabled under the definition of the ADA because you didn't prove it. And Maryann, this is a good one because you and I have discussed this many times. No, that's correct. I didn't prove it. My doctors did. The doctors you sent me to in your appellate directory for psychology, for hearing, for mobility, for neuropsych, for psychiatric, for social worker, for parenting, they proved it. Okay, my ADA advocate amplified it for you and communicated in a way I could not at the time because I was speaking tangentially, wasn't speaking coherently, head spinning, vertigo, dizziness, blurry eyes, pain, having to get breaks in court because I'd have such a headache pain. My ADA advocate explained it, okay? And court administration, when they said I could have a note taker, Judge Schauer, which you denied access to, okay, they explained it. But it's like, oh, but what do I do, court administration, when Judge Schauer denied access to my note taker? And then she throws me in jail for not remembering when I can't take my own notes for cubital tunnel syndrome, or they say it was owner release surgery. There was surgery in your elbow where they pulled their nerves out, Maryann, so that you have restoration in your fingers that were just numb. You can't write, right? They said, oh, Mr. Fishman, you could sue Judge Schauer in state court. Sue her in state court. She's your employee. You give her a paycheck. The ADA mandates places of public accommodation have to be accessible. Not a judge accesses or not accesses. Not a judge agrees or not agrees. Places of public accommodation have to accommodate the disabled. And they're like, no, we agree that places of public accommodation have to. But if a judge denies it, you have to sue the judge. I have to sue the judge. you know, and so like you said, think about the insanity. You and I have to sue judges, right? Think about that. You have to sue judges. But listen, what they also did in the American Disabilities Act and the amended ADA, we're talking about Congress and the laws that both Bushes signed, was that there is no immunity. There is no state sovereign 11th Amendment immunity. For those of you in your audience, we repeat it over and over again, there is no judicial or judicial administrative or state sovereign immunity for denying access or communication to a disabled person to a state courtroom. I want to make that clear. This was codified in Tennessee versus Lane. This is our Bible. Tennessee versus Lane was a 2004 law, Maryann, signed by Judge Stevens. Okay, 5-4. And it basically said that state courts, state judges, state administrators, state officials, city officials in states are not immune. No state sovereignty, no 11th Amendment immunity, no immunity for denying access or meaningful communication or meaningful communication and access or meaningful participation of a disabled person in a state court. And actually, the deciding judge was Sandra O'Connor, the Reagan. Remember, we had the Reagan Democrats, right? So here we had Sandra O'Connor, Ruth Bader Ginsburg. We had Judge Stevens appointed by Gerald Ford, Republican. And Gerald Ford said, when asked later, why did you appoint Judge Stevens? And he said, I wasn't thinking of a Republican or Democratic judge. I wanted someone with a brilliant mind who could be open to the law. So here Judge Stevens wrote this with Breyer, okay, as we said, Ruth Bader Ginsburg, O'Connor, and it made a 5-4 majority and has stood, thank God, the test of time, because in Lane's case, Lane was a paraplegic, disabled man who was denied access to a second floor courtroom in Tennessee. And Lane won in the federal district court and the federal appellate court that he was discriminated against because the judge refused to hold court in the first floor. And the judge refused to hold court in a courtroom that was accessible. It was an old building that was over 100 years old, didn't have an elevator. And the judge at the time jailed Lane. It was family court, right? Because Lane refused to be carried. Here you have a veteran.
Oh, yeah.
A veteran. We should worship and thank our veterans for their service. We love our veterans. A disabled veteran is being humiliated because the judge says that he won't allow the court officers to carry him to it. Why should he be carried? It's not a baby. He has no legs. So the judge got raspy with him and curt, and you saw the record in the online case saying, this court is very frustrated, Mr. Lane. We've offered to carry you to the courtroom. And Lane said, why don't you have court on the first floor? He says, my courtroom's on the second floor. Why don't you have an elevator? There is no elevator here. It's an antique building. It's grandfathered. But you have two options. My officers can carry it. But you know what? You're pissing off the court, Mr. Lane. So I want you to use those long arms and pull that rail. Carry yourself up. You won't allow my officers to carry you. Well, thank God. That disability organization sued. One in Tennessee that is disability discrimination. One that there's no immunity for the judges. One there's no immunity for the courthouse. And one, how dare you humiliate a veteran who served our country, who bled for us, who lost limbs for us, is to be carried to a courtroom? Carried? Is he a baby? Doesn't have a bottle. He doesn't wear a diaper. Ridiculous. So, Maryann, actually, that got appealed from the state of Tennessee. Because if you and I, as you discussed, right, many times, you and I appeal the Supreme Court, come on. You have a greater chance of winning the lotto than getting permission to appeal the Supreme Court. But if you're Tennessee, right, if you're a state, that goes up to 60%. Oh, that goes way up if you are a state. And the only people higher than states, right, are the president, right? Your president appeals, it's like over 75% chance he gets hurt. So Tennessee was foolish enough to bring this, and Stevens needed the fifth vote, which was O'Connor, because the other was a Democrat, and O'Connor said this: "I'm going to allow immunity only for state courts, because state courts here in majority cases, okay, not federal courts, and there's 50 states, right? So how do we not allow disabled and disabled veterans access state court? So I'm going to allow the waiver of 11th Amendment immunity because the state court's access is so crucial to the administration of any type of justice. And thank God we had someone level-headed named O'Connor. Thank God, because we didn't have that law. And so judges protect judges, let's be honest. So when I won on July 16, 21, in my lawsuit from 2018 for being denied communication accommodations, meaningful and effective communication, which came out of that law. Meaningful and effective means personalized communication to my disabilities. My disability is different than others. I have 2 neurostimulators. I have a simple neuralgia, sleep apnea. I have hearing disabled. I have TMJ. I have nerve injury. A lot of it's nerves. Very powerful impact accident, June 10, 13. Nerve injuries. So the point is, meaningful and effective communication for me is different than you, different than your son, different than my kids. And to have this explained by the Professor Einstein of disabilities, Donna Drum, who worked for Bowie's, and mock her. Forget about me. And you and I talked, is this a male thing, female thing? No, they hate you in family court. It doesn't matter. Right. Sex doesn't matter.
They hate everybody.
Everybody. From Michelle Schauer, Judge Michelle Schauer, disgraced judge, to be yelling at a distinguished former head of the Women's Bar Association, former head of the county bar, an AD advocate, calling her a monster, a female attorney, admitted to the bar for advocating for my disabilities, shows that she has no respect for any law, state or federal.
And she probably hates herself as well. So they hate all of us parents, and they all hate themselves.
Think about it. It's bigger than you and I.
Right.
It's a female judge. It's a female attorney, a female AD advocate. And, you look at the law and you're saying to yourself, why do judges hate one party? Oh, well, let's talk about it. Disabled parents lose custody or lose visitation over 88% of the time. I was in the Brandeis study with Robin Powell, one of 45 families, and they talked about my situation while this was going on, before I won the federal case, ordering the accommodations against the state, with Judge Schauer's name on it, Judge Greenwald, Judge Oliver Gordon, 2 other judges in my memory, Carol Jordan, right? Nancy Barry, the head of administration, right? Winning this accommodation, I had to sue to get an accommodation. I had to spend over $100,000 legal fees and over 50,000 transcripts to win an accommodation. Someone who's disabled and can no longer do the things he did before the accident, right? So before this happening, that we have to have this situation where we have to prove it. We have to have federal marshals serve these judges, and then the judges retaliate today. Like, oh, you'll never see. Judge Schauer said to me, you'll never see your kids unsupervised again. I never have since her disastrous tenure. And instead of, as you said, the people above her, the judges in the appellate division in Brooklyn, our Court of Appeals, the Supreme Court, instead of them giving permission to hear a case, they send you around from party to party, ignoring the issue. Because they're like, if you search family court, of course, you won't just see Judge Schauer. Judge Schauer has a greater percentage of disabled who lose because she hates disabled people. Let's face it. Mm-hmm. Judge Schauer hates disabled people. Others are looking for someone to hate. Oh, memory impairment? Oh, okay. So they got to lose custody. They got to lose visitation. It's got to be supervised. Why? If I have my aid, if I'm paying for my aid, or if my aid is supplied by the court to accommodate me, why do you even bring disability into the equation? And states like Kentucky and California specifically said they won't. In California, you had Governor Schwarzenegger, Arnold Schwarzenegger, the Terminator, movie actor, then governor, do a deal with Democrats saying disability cannot be used against a parent in Supreme or family court unless the disability of such a nature, Maryann, that it cannot be accommodated, and the safety of the child is in serious danger of harm. Because think about it, everything can be accommodated. Imagine we have people and parents who are paraplegics. They might have 3 aides. Can you imagine if they had to fight to have their aide to go see their kid? Can you imagine? This is ridiculous. You imagine if, you have a wheelchair without a motor and you're in a courthouse, needs to be pushed. But you have no one to push the wheelchair, so you can't get to the courtroom, and you can't push yourself because maybe you have an arm injury like I do, or maybe you paralyze your arm. So you can't push yourself. You can't get to the courtroom. So you're going to lose? Come on. So what's the difference between my disability and how they accommodate me? We showed you that without my stimulator on, I get vertigo and dizziness and have to be on my walker. Okay, you don't care. You don't care. And so what you're doing, Judge, is that you're not just hurting parents who are disabled. You're teaching kids that empty doesn't matter.
Exactly. Exactly. I'll tell you this, when I was in a child support contempt hearing, I think that's what it was, because I was in so many contempt hearings, or this was actually just in the basement of the Erie County Courthouse, where they do they have their officers that are supposed to run the figures, and people don't bring in their W-2s and they get away with it. But anyway, my ex and his attorney were both looking down. They always look down. They would never look at me at all. So I said, "What's the matter, guys? Why won't you look at me? Think you're doing something wrong?" And his attorney answered, because I have a lazy eye. I said, "Can't you guys look me in the eye?" He goes, "Which eye?" And I yelled at him and I said, "So you're making fun of someone with a disability? That guy has no empathy."
You said it. Education is the key.
Right.
Like you said, why are we doing this? My youngest twins are almost 18. And again, I'm so sorry you've gone
That's
through
okay.
this. I
Well,
love coming on this show because you really know what it feels like. They put you in jail for months, and you're a very nice one, great mom, deserve none of this. And
I
you've
only
taken
made it a
this,
week in there. I only made it a week. My 79-year-old dad bailed me out, thank God.
but they gave you a couple months sentence.
Right?
No problems, right? No
Right.
problems. Main circulation, torture, horrific smell, hellhole,
Hmm.
sounds you couldn't repeat.
Right.
Okay, noise, defecation, no privacy, no female privacy. You go to the bathroom. I mean, these things never leave you. That experience will never leave you. There's no
No,
way.
and the closing of the doors. And here my ex was telling the kids that, oh, she'll be in a nice prison where she can knit and play tennis. And it's like, that's what they told me. The kids told me when I got out. I said, no, no, I was in an actual prison in general population. This was
With a heart
not,
condition.
no tennis courts there. Sorry, I'm not rich.
Mine had made sure that the fact that I was jailed was hidden from the kids. Okay, and they lectured me that you couldn't mention to the kids afterwards, even my teenage kids, that you couldn't mention that you were jailed or you'll never see your kids again. The threats,
Ooh,
you know,
that's wrong. That's
yeah,
wrong.
yeah, and never explained them. And then when we brought up um, to subsequent judges, why don't you allow the kids to attend um, cognitive 101 or learning disability accommodations or learning why daddy has disability, has an implant, when we had free customized courses offered by um, the Westchester disabled organizations like Westchester Disabled on the Move um, and Westchester Independent Living Center. The judge's like, no, no, we can't do that. And the other attorneys advocating against it. And like you're saying, attorneys lack empathy. They have to win so badly that they have to fight below the belt.
Oh
If you're in
yeah.
a boxing match, Maryann, right? You hit below the belt, you hit the genitals, you hit the strict area, you disqualified, you lose the the match, right?
Yes. Yes.
Okay. Why doesn't the attorney lose the license?
Right.
you
Well, I reported
know?
him. Yeah, I reported him to the U.S. Supreme Court Disciplinary Board. That's where we report in Pennsylvania. And I got a two-page letter back saying that, you know, they were apologizing for his behavior, but it wasn't unethical enough. And why would he do that? I think I called them up and I talked to the attorney that printed that out, and I said, well, I don't know why he would do that about the eye thing. And it's like, it's got to be unethical enough to make fun of someone. And Taylor was good at that. Attorney Taylor was good at perpetual lying and making fun of people. But why didn't the officer there, the conference officer, say, hey, wait a minute, that's uncalled for. You guys step out of the room or whatever. There was no admonishment. She just sat back. It's just crazy.
It is. I mean, it almost should be a continuing education requirement for continued licensure as an attorney. They should teach in law school um, empathy for the fellow person. We know in my ex-wife's case, let's talk about Legal Services Hudson Valley and Hudson Valley Justice Center. They take federal funds. If you
Mm-hmm.
take federal funds, you can't oppose accommodations for anybody. And they would write these briefs in appellate court saying, I didn't prove I'm hearing impaired. I didn't prove I need a note taker. And using public funds to do it over and over again. And even Biden's DOJ called him out. Obama's DOJ said you can't use federal funds. Legal Services eventually withdrew from the case once they had a formal complaint against them. But Hudson Valley Justice Center and disability discriminating attorneys there, like Virginia Folksrod representing my ex-wife now, have no problem continuing to oppose ADA accommodations, to deny ADA accommodations, to restrict access because you're disabled, when they have more disability training than your average lawyer, and they take disabled clients. How can they use public funds? The answer is they can't. But like you're saying, DOJ, Department of Justice, has so few resources that when you complain to them, as I did more than 7
Oh,
times,
yeah. Yeah.
they
Same
say,
here.
sue yourself. Sue yourself. Oh, really? You might be able to find an attorney. Oh, really? Sue yourself. You know, and to get assistance, you had to pull teeth and file complaints against disability organizations. I had to actually file complaints to DOJ against Disability Rights New York, who eventually helped me. I actually had to file complaints to get them on the case. Isn't that absurd? And you know what came out, Maryann, was after, as I said, 49 months of Judge Schauer
Oh,
refusing to give me a final order I could appeal, forcing me to go to federal court, throwing me in jail for 3 weeks, humiliating me, limiting my access to my kids, mocking every disability, mocking every accommodation, seeing my neurostimulators and calling them Walkmen, saying that they're illegal and I should be arrested because I brought them into a courtroom. I said, Your Honor, your court officers had to scan and clear me. They can't take these away. I need them to adjust my stimulator during your hearings, which are 9 hours. It's not a recording device. They would have confiscated it. Well, it looks like a Walkman to me. It looks like a Walkman to her. And yet you complain to the Commission on Judicial Conduct. Bob Temjecki has been there 36 years, does nothing. No problem. You complain to the appellate division. You're not disabled. You complain to the Court of Appeals. It's not appealable. 7 times, Maryann, it's not appealable as a final order. It's not appealable in the New York Constitution. No, it's their way of saying you're never going to get an appeal, because if we grant you your appeal to show your judge discriminated, it's going to show hundreds of judges in New York State have discriminated, particularly in family and divorce court, for years, because it's a pattern. Because you complain to everyone, and the only place I said I got justice was in federal court on July 16, 21, ordering the accommodation against the state. And Judge Schauer's response, as I said to you, because somehow she reassigned the case to her in April after I got my support terminated for parent alienation, something no one does. An order signed terminating child support for parent alienation, okay, disability parent alienation, assisted by judges, okay. Judge Schauer said, I just want to tell you on the record, Mr. Fishman, your order against me for the accommodation is only good against me in federal court. It's not good in state court. Okay. And you're going on podcasts and TV interviews and newspaper articles is all lies. It's just, I would say it. Your order is only good against me in federal court. I said, Your Honor, you're proud of this? I said, you're proud of this? You're telling me, number one, it's not good in state court. Number one, Your Honor, that's untrue. She says, how's it true? Well, Your Honor, I'm not the smartest person on earth. I said, but I got a big Jewish mouth. And my 3-sentence order, my 3-sentence order, Maryann, right? It doesn't say it's only good in federal court. As a matter of fact, it doesn't have any limitation. It says the court's ordered to provide the accommodation. That's what it says. Mr. Fishman, everything you say is a lie. Your Honor, by the way, if it's only good in federal court, why do you have a court reporter here, a real-time transcription reporter? Mr. Fishman, everything you say is a lie. Court reporter, can you please identify yourself in the record? She says, yes, I'm court reporter authorized by this because Mr. Fishman has a court order against me and the court system provides the accommodation. Your Honor, why are you paying for the accommodation if you don't get it? Mr. Fishman, everything you say is a lie. Okay? How do you wear a robe? How are you not fired? How are you able to have any ruling after you threw me in jail, after denying an accommodation, after denying a note-taker access to your courtroom? How do you have any ability to continue to judge others, as you said, shame on every boss she's had. Shame on every appellate court. Shame on the court of appeals. Shame on every governor that have done nothing to end this. Because at least, as you said, somehow in my rehabilitation friends network and people like you that air these grievances, I've been able to somehow get to federal court and get an order for the accommodation. What happens if they don't? I get called, Maryann. I man a suicide line for veterans and TBI survivors. I get called, and I hear these people crying that no one accommodates them, no one will help them. And you say, well, I'm here to help, and I'll do everything I can. And then they complain. They say, Mark, thank you for just even listening. And then you say, I've been told no. Maryann, it's over 50 times my New York court administration to get the accommodation. No. And to me, it goes in the one ear out the other, right? Because I've told no so many times. You sue or you make your argument and it eventually becomes a yes to the accommodation, hopefully. But my point is, your average person doesn't have this resilience or doesn't have this fervor or doesn't have this continued, I don't know, resilience to just run into the boxing ring, get beat up every time. No, you're a bad guy. You make up your disability. You're fake. And in my case, my ear does go numb, so maybe that helps. I'm going to get this accommodation no matter what. I will take you to the highest court anywhere. I'll get a megaphone. I'll yell out. You guys want to strip search me 8 times a day for 2 weeks in state county jail. You think you're going to see something that's glamorous. There's nothing here, guys. You count my scars. You count my rashes. You see my skin tags. You see my abrasions, my hives. You can see my boils on my skin. Like, really, you really think that's going to stop me from doing accommodation? Oh, we're going to throw you in jail? Really? Really? They'll keep me in a jail hospital. They're not going to keep the guy with 2 explosives in his chest, unescorted, unguarded. What do you want? You want a walking explosion? Which,
Right.
ridiculous,
It's
Maryann.
like you have a warden with more brains than a judge.
It's true. And the warden said to me, he said, your judge should be here, not you. And the psychologist for the first entry, because they say, do you have a mental injury? Yeah, I have a cognitive impairment. I have post-concussion syndrome. I have traumatic brain injury. I have a simple neurology. So they interview the first night, and they say, do you feel suicidal? Are you going to kill yourself? I say, I see you're here because it says you disobeyed the judge's order and you sent gifts to the kids. And they said, how does someone go to jail for sending gifts to the kids?
Right.
And the psychologist says to me, she says, I don't understand this. She's like, this doesn't make any sense to me. I don't even know why you're here. I don't even see a criminal charge. Can you imagine, Maryann? It's no criminal charge. You're here confinement.
Right. And those gifts were sent through Amazon and they really weren't ordered by you.
My daughter.
Right.
My daughter had a gift card for me for $1,000 to help her. She ordered gifts. My mom sent gifts. My aunt sent gifts. Right. And they're saying they were too voluminous. I remember my daughter came to me. You want to talk about cruelty. She's a beautiful young lady like you. And she said, Mom, you only bought me one bra, one brassiere. She said, Daddy, will you buy me other ones? And I went during my visit. I took the supervisor and the 3 other kids. We went to Macy's. We bought her, bras in nude color and black and brown. I mean, the supervisor went in the dressing room with her. I sat outside with the boys. I mean, come on.
Yeah.
It's a girl. What do? You give her one bra? Come on. You're humiliating her because she's becoming a girl and growing a female out. This is disgusting. And then my ex goes to court and says, oh, he can't pay for the supervisor or can't pay me child support on time because he's buying bras for our daughter. Really? In New York, there's no requirement you spend the child support on the kid. So, honey, you ain't doing this. And my daughter's crying because she's only got one bra, and she's afraid you're going to yell at her, punish her, because she asked for more. And you're chastising me for taking my 1 of 2 day visitation supervised and going to a store and buying brassieres.
Yeah,
You're throwing me in jail because my daughter bought gifts for my kids?
I can't believe she brought that up in court. That is just the most dumbest statement I've heard.
You should see Maryann. She would then, so we're talking about 2014-15, the beginning of the advent of the iPad. So my ex chastised me for spending $600 on iPad for our son, who's autistic, who couldn't hold a pencil. And before I got to school to agree to give him an iPad as accommodation, I bought him one. And she says, oh, yeah, he sent $600 instead of paying his child support on time. An accommodation of autistic son. And she said, oh, he's not disabled. Huh? He's got an IEP. He's got AIDS. He's got help. You don't oppose his aides, but you oppose mine coming to
Right.
quorum. Anyone to help me? You say I'm not disabled. You fake it. Matter of fact, I'll never forget it. My ex filed a fraud report with Allstate Insurance, Maryann. She filed a fraud report saying my accident was a total fraud. I made it up and that it was fake and that it wasn't serious. She wasn't there. I was in the emergency room, for hours. I have a neurostimulator each chest. I have a neurosurgeon. I had a broken toe, torn cuff, torn rotor, sprained knee, sprained back, high blood pressure since 13. And you go there, and so I have to survive a whole fraud investigation to prove my accident, which, by the way, the other side admitted they hit me from behind. In New York, if you hit someone from behind and you're the person hit, you're not moving, that's 100% responsibility of the person that hit you. Oh, no, but
Right.
it's not serious. Really? It's not serious? Then why do I have implants? Why do I have nerve surgery on my arm? Why do I have a torn covered rotor? Why was in PT all these hours?
Now,
And
how
you have to
long,
defend this?
right, how long were you defending this with the insurance company?
She filed 2 fraud reports. These fraud reports lasted 2 years. So at the same time that she was accusing me of not paying support, my insurance company was delaying payments for medical care, lost wages,
Oh,
reimbursement, daycare. Well, they set you up to fail. And meanwhile, after obviously the insurance company cleared me twice with their own independent investigators, right?
right.
Do I get any compassion or empathy from family? Oh, no, you're a deadbeat dad. You didn't pay. I'm not working for 2 years. She goes and files a fraud report. You reward her? You reward her? Because as you say, this isn't about what's the best interest of the kids. This is about, oh, you're going to lose no matter what. Why didn't you tell me that then in 2013? So those of us who could have just sued in federal court back then and ended this sooner.
Mm.
I stay up at night, Maryann, and I work up with incredible headaches. And I actually feel horrible that I wasn't able to get Judge Schauer fired.
Oh,
I'm happy to tell your audience that Judge Schauer's last day is December 31st, 2025. Thanks to you, Maryann. Thanks to advocates. Thanks to federal judges. This judge is terminated. She is going to be gone. But the
that's
lawsuit
awesome.
will not end. We will continue in federal court until
Hmm.
all the judges like Judge Schauer are fired and terminated. Because like you said, there's no re-educating them. There's no
Right.
teaching them compassion empathy. They don't understand the concept or word.
Oh, no, no. Because I think I told you that after my heart attack, I had the stack of papers from the cardiologist that I delivered to her lair, right? And I gave it to her secretary. So she knew that I had had a heart attack and a cath and 3 stents to the LAD. And when we were in contempt hearing for child support the next week, she didn't care about the cardiologist notes from God. She said, she gave me a physician verification form and she said, you have your physician, your family doctor fill this out and you've got 7 days to do it or I'm going to put you back in jail. And I thought, what doesn't she get? Is she this stupid? Anyway, she's not on the bench either, wink, wink. Yeah.
I'm so sorry you went through that. And I wish I could say in New York that it was a liberal state or a pro-disability state. We just had December 3rd, International Disabilities Day, recognize disabled people. We have our DA Kachesi, District Attorney Kachesi, who's still prosecuting me, trying to throw me in jail for the 45 days for not violating an order of protection I never got, for not going on a property during a supervised visit where I paid $500.
None of this
Where the
should have
cop, we
happened.
now have the video. If you
Oh,
guys want to go see it, NewRochellePoliceAbuse.com. Now the video of the cop telling my aide, I didn't have malicious intent to commit a crime. I didn't commit a crime. Didn't intent to commit a crime. No purpose to commit a crime, right? Jury never saw it. Had to get the video in federal court. Then you had to get a special video player because the video player the cops used was proprietary. So you couldn't even make the video accessible to the public. So difficult. Finally, we've displayed it on NewRochellePoliceAbuse.com and emailed it out. And I got to tell you that you say to yourself, they, meaning the state court system, not only assumed that you wouldn't pierce judicial immunity, that you wouldn't get some federal court or some judge to say the accommodations are ordered, which basically means the state judge, the state court committed disability discrimination. Failing to accommodate a disability when you acknowledge the person disabled, when the accommodation is reasonable, is disability discrimination.
hmm.
And Mary, we define reasonable as being customized, but reasonable under is very simple. Is the financial hardship for the court to provide? Does it change the nature of the purpose or the meaning of the proceeding? Me having a note taker that I provide, or me having real-time transcription, which, as you and I are aware, we have it on your podcast with Zoom or Microsoft Teams. I flick the switch. You flick the switch. Administrator turns closed captioning on. Marc Fishman turns captioning on. And you and I talked about we can control the size of the font. We can control the letters. We can make it a certain color, right?
Yay. Yeah.
But they won't do it in state court, right? Right? So again, we want to get down to basic discrimination because some of these laws are way too complicated. So for your audience, okay, if you request an accommodation in a place of public accommodation, such as a courthouse or a court program like supervised visitation, meaning the court program at the Y or at the school or at the visitation center, if you request an accommodation and they acknowledge you're disabled and they codify a disability and the accommodation is reasonable, they have to provide it. They don't provide it, they have to give you a interactive session where you can explain the need for it. Title II of the ADA, interactive session, private between you and the judge, you and the court administration and the judge, no adversary, for you to explain which your medical doctors or your medical documentation, why you need the accommodation, absent the adversarial process, right? And if it's reasonable, they must give you your preferred request. Again, I want to say Title II of the ADA, your preferred request, accommodations with state government, state court, state government. They must give you your preferred accommodation unless it's too expensive or it changes the nature of the program or hearing. My friend Maryann, me having a note taker, silent, taking notes, or stenographer, or recording, doesn't change the nature of any proceeding. They're sitting there in the audience, or they're sitting next to me at the table, and they're taking notes in minutes, and they're getting paid to do it. Okay, most states will pay for it. New York won't, because New York discriminates against disabled people. They don't want you to understand. And New York doesn't want you to understand family court, because as you and I have discussed, unlike a lot of family courts across the country, we have no court reporter. So there is no one to call up and say, can I have a transcript? No, we have digital and analog reporting. And if the family court judge wants to hold it up, she won't release the recordings. Judge Schauer held up numerous recordings. Judge Schauer edited transcripts to edit out what she said. And Judge Schauer had my transcriber, Alan Kachowski, fired. She went to OCA and said, it's not that Mr. Fishman doesn't hear. His transcriber does a poor job. I didn't prove the transcribers. There's a dedicated list of transcribers. He has too many inaudibles. That's because he's not registering. He doesn't have a hearing disability, Your Honor. If he's not registering, it means you're in an inaudible courtroom or you don't talk clearly. No, Ms. Fishman, everything you say is wrong. Your Honor, it's like 13 inaudibles in each page. You expect me to understand what it means? You know, and so she went to the head of OCA. She went to the head of court transcription to have him fired, have him say his transcript was substandard. Meanwhile, other transcribers say all the time, we have to sit there for hours and hours to try and understand, because at that time in 2015, 16, 17, 18, 19, Maryann, a lot of courtrooms were inaudible. A lot of courtrooms are in a town hall or police station. They're above the farmhouse. If they're in upstate New York, come on. You have Western Pennsylvania. Come on. You have some courthouses which are not court buildings like you have in Manhattan or like you have in Harrisburg, right? So think about it. You're having a transcript trying to understand the words. Meanwhile, a hearing impaired person, you honestly expect them to understand anything? You should expect they won't understand anything. No, Mr. That's your fault. Your fault. Your fault. Why is there about fault? The ADA doesn't mention fault. The ADA mentioned disability need to accommodate. As I said, you got to get your preferred accommodation. We shouldn't even be having this. It's an insult. Judge Schauer made it happen because Judge Schauer thought she'd never be terminated. Her last day is December 31st, 25.
Yay.
Can't teach an old dog new trick, right? Thank you, Maryann, and the audience. Everybody helped us get rid of disability discriminating Judge Schauer. Okay? Let it be a warning to other judges. If you're fair, impartial, and you're neutral, and you support the will of justice and Lady Liberty, be a good judge. If you discriminate against disabled or the veterans, you're going to be terminated. One way or another, you're going to be terminated from your job. You're going to lose your pension, your robe, and you'll be remembered as disability discriminating judge. I guarantee you, Judge Schauer is going to be remembered as a judge who discriminated against disabled, because man or woman, her decisions against someone with an impairment are just disgraceful and numerous.
Yes.
Residents are aware we now have a second website called protectnewyorkers.com. PROTECT New Yorkers, plural.com. Please fill out the web and please fill out the petition.
Yep.
Put your name and email. We will contact you later. We are circulating a petition to amend. In New York, we have the Law Enforcement Misconduct Office of the Attorney General. In 2021, Governor Cuomo and the state assembly, the state senate passed a law to investigate bad cops, misconduct cops, problem cops. Okay. In New York, we have 38 cops since labeled pattern misconduct. Mine's one of them. And instead of reversing my conviction, which I continue to fight to do, where the cop now admits on camera, I didn't violate any order and didn't go on a property and didn't have intent, no malicious intent, can't be convicted of a crime, right? In federal court that we got, and that, we're now in federal appeals court fighting to show that the cop discriminated against my disabilities, not only by intentionally withholding the video from us pre-trial, but the fact that he refused to accommodate and give me my disability aid to help explain the 30-page order that allowed for the visit that you arrested me for. Okay? So now we have this. Attorney General Tisha James, in April 21, has the power and the authority and the requirement to investigate bad cops when the cop is referred with 5 or more instances in the past 2 years. 5 or more instances. 5 or more instances, 2 years. So naturally, as I've been saying on the show, Maryann, unbeknownst to you and I, in some of your interviews, officer now terminated, Lane/year, was referred in January of 2022, within 2 years of my conviction, by the way, for not violating order of protection, not going on a property, not attempting to, sitting in a car waiting for my autistic son, with a disability aid paid $500 with my disability driver, right? So I didn't even drive the property, right? That I'm convicted of disability discriminating Lane/year, who now admits he never read the order of protection, just arrest me for it, right? Okay, yeah. Was investigated for over 25 instances of misconduct, okay, and fired in May of 24. Wasn't made public until December 24, okay? And me having a headache on December 24, we found it online, and we found out this law called Law Enforcement Misconduct Investigative Unit, and Tisha James spent 29 months investigating my cop while I'm in federal court, while I'm fighting Judge Schauer, while I'm fighting the police in federal court, and suing Marc Fishman versus Lane/New Rochelle, okay, all along, and New Rochelle not disclosing it to the federal judge, Ramon, not disclosing it discovery, not disclosing it. We get it, okay? And here we have proof that the Attorney General says he arrests people falsely, and he commits misconduct, and he shuts off cameras during arrest, right? We have all this. And ever since then that we got this, we've gone to the DA, when the DA has refused to even acknowledge the report, DA Kachesi. DA Roca before in Westchester. Refused to comment. He's the only Westchester cop labeled misconduct. He's the only Westchester cop forced to retire. He gets to keep his $93,000 pension, okay, for his 17 years. But can you imagine, Maryann? There is no provision in New York state law and no requirement for the DA or the Attorney General to investigate all of the wrongful convictions of the cop. No requirement for them to even clear all the convictions. We have 38 rogue cops. Most cops are good. Most cops are great people. Mine, who arrested me, Lane/year, wasn't. Only guy in Westchester. Only cop in Westchester. 1.1 million people in Westchester. So what we're doing, Maryann, is we propose an amendment to the law and going back to all the senators and assemblymen who voted for law enforcement misconduct. Law enforcement misconduct came out of New York State's reaction to the killing of Floyd in Minnesota. People were aware, who've seen that horrific instance. No doubt, under the ADA, Floyd was disabled. No doubt, instead of accommodating him, they killed him. Okay, horrible. No words. In New York, they had riots. They had protests, a lot of the most populous city. So New York State came up with a law saying, we are going to deal with a mechanism to hold problematic cops accountable. 5 on 1 since in 2 years, the police chief or the mayor must refer them to the Attorney General for investigation. Mine was referred, and in the FOIL documents and in the discovery, okay, that came from the Attorney General and the police, she was aware of my case. She omitted. Why did she omit my case, Maryann? Who was she defending against real-time transcription note taker? Because Tisha James was defending Michelle D'Ambrosio. Nancy Barry in your court says, at the same time, we're in federal court, on the accommodation, she's defending him, and she knows this cop was acting at their behest, okay? And here, she doesn't disclose, she doesn't recuse. There's no requirement to recuse for investigation. She's got a conflict, okay? So what this law provides is obviously the Attorney General would need to recuse if she's defending the cop or his actions in another court, and that within 60 days of the cop being terminated or disciplined via a public determination by the Attorney General of police misconduct or false arrest or any of the above by law enforcement misconduct, that the DA must investigate all the wrongful convictions of that cop, and that that person is aware, if they're jailed or not jailed, of the investigation in 30 days to be able to request bail and have determination on whether their conviction stands the muster and the smell test of guilt or innocence based on that cop now being labeled false arrest or pattern misconduct. Very simple. The Attorney General in New York State already has the authority to investigate wrongful convictions if the DA relinquishes. What DA is going to relinquish the fact that they made a mistake? Now we want them to require it. So please, ladies and gentlemen, tell your friends, tell your neighbors, tell your parents, tell your kids, protectnewyorkers.com, protectnewyorkers.com. Put your name and email address. We'll then contact you. We're giving this to state senators and assemblymen to amend the law enforcement unit to require the district attorney to investigate all the wrongful convictions of those 38 cops and more, because they're law enforcement misconduct in New York. Okay. And have the governor see that we have thousands and thousands of people that want this amendment to a law, which requires no money. We don't want any additional monies. We don't want any additional staff. The Attorney General in her law enforcement misconduct social justice unit has ample staff to investigate all the convictions if the DA won't. And the DA knows their wrongful convictions. In Westchester's case, you have a staff of 284 people in the district attorney's office, and they can't investigate Lane Schlesinger. They can't even acknowledge the wrongful conviction. They can't even acknowledge he's fired. We've had all these post-conviction motions, and the judge won't even acknowledge it. The appellate division won't even acknowledge it. Shame on them. But you know why they won't acknowledge it, Maryann? Because it'll be the biggest pattern cover-up ever. That not only did a disabled person with 2 batteries in his chest, a metal hip, wires in his head and elbow, who spent 3 weeks in jail, okay, who's got a warrant to arrest because he won't serve 45 days because he's in rehab in California, okay, with numerous medical issues, is challenging you people in federal court and showing how you have covered up over and over again what is obvious innocence, just to make sure I never see my kids, my twin Sky and Aiden, who turned 18 in July of 26. You want never to see my kids again. You hate me so much. Why do you hate me? I've helped tens of thousands of New Yorkers and hundreds of thousands of people across the country realize they need accommodations and they can get it. And in New York, have it ordered. But you hate me because 5 judges got served by U.S. Marshals and were called out by the circuit for denying communication accommodation for a disabled man. You think that I need retaliation and punishment. Shame on you. And shame on your bosses. And like Maryann said, it's sad. I hate to say it. We need new judges. We need new appellate judges in New York. We need new court of appeals judges. Because you're not going to teach old dogs to trick. They refuse to acknowledge their loss.
Right.
And you know what? I'm here in California. Come get me. Come put me in your disability jail. Come pay for my rehab. You want your 45 days. 45 days for what?
Right. And, Mark, I'm thinking the taxpayer needs to know this stuff. Because if they knew that they're dragging your case out, not letting you see your kids, this ADA accommodations not being honored with all your disabilities, the taxpayer needs to know that there's a judge that wants to put you in jail. And that's a waste of money.
Judges protect judges, Maryann. And the fact that 3 judges in the federal Second Circuit ordered the accommodation, understand it was 3, group effort. Republican, Democrat, or Independent, Maryann, you and I have discussed this discussion over a dozen times. Come on. Judges protect judges. A Republican judge is going to protect a Democratic judge from sovereign immunity. A lot of judges feel that Tennessee versus Lane was an aberration. They don't view it as a victory for the disabled or protecting the disabled. How dare there be an exception to immunity for a judge? Why? Most judges, good judges. I think most federal judges care. I think most federal judges, you have appointment for life. They care. They give me time to speak. They give the adversary time to speak. We're never interrupted in federal court. Always have patience, courteous, and their lifetime. So, I mean, they're there, right? But in state court, I'm sure you can tell me over a dozen instances where the judge wouldn't even let you complete a sentence, let alone make an argument. A witness? Oh, Fish, you can't go any witnesses, Fishman. Screw you.
Yep. They shut you up. And it's really a shame. Something has to be done.
I mean, Maryann, think about the instance. We have the Attorney General of New York who just got off on a technicality, says that the prosecutor wasn't lawfully appointed. I don't know if they are or aren't. I'm not an attorney, but all I can tell you is she gets off on a technicality. Yet Marc Fishman has her 11-page report, single-spaced, from Lane's last year. It took her 29 months. It talks about 5 instances
Mm.
of inappropriate misconduct, insubordination, failure to follow rules, false arrests, and I still have to prove my innocence?
Ugh.
You know what? There is no innocence or guilt in New York. The whole justice system is thrown upside down. Because if a disabled person has to fight this hard to get an obvious reversal, what's the purpose of law enforcement misconduct? Oh,
Mm.
we fire the cop? Okay, but what happens with the consequence of what that cop did? Lane's last year had 17.6 years of false arrests. The way he thought, his pattern. He had a disability. He was an Iraq veteran. There's no doubt. He also had an arrest in North Carolina for a DWI. And yet we didn't get that information, right? We didn't get the information.
Mhm.
He was disciplined. He had suspensions. We didn't get a disciplinary record. In New York, we have the enhanced discovery laws. Enhanced discovery laws for every defendant to get all the information that could be exonerated, including disciplinary records, videos, audios. But in Marc Fishman's case, you get nothing because you sued the judges.
Oh,
You
yeah.
sued the judge. You don't even get real-time transcription. Screw you.
Retaliation.
It's real.
It's real.
People like David Zuckerman, Judge Susan Capicci, Schauer, you all need to be fired. And the new judges, we need to educate, require continuing education, and we need to have at least every 6 months a very simple ethics course. I would say 1 hour, Maryann, what do you think? Every 6 months, saying, you know what? Being a judge is a privilege.
Hmm.
Wearing the robe is an honor. Being called Your Honor and Judge, Madam Judge, or Mr. Judge is not a right. You weren't born with it,
Hmm.
and it can be taken away like that. So we should remind you, with other judges, that it is a privilege. It's a duty. It's a high responsibility. And if you discriminate against the most harmed, the most injured, disabled veterans, disabled people like me, victims of a car accident,
Yeah. Yeah.
people who are in wheelchairs, people with MS, autistic, you discriminate against us. You're not only violating your oath to judge, you're violating your oath as a human being, that you
Hmm.
don't have empathy. Remember, honest, honorable judges are empathetic. They show compassion. They're caring. You know, I saw Judge Schauer April 28th for the first time in 7 years. It
Oh,
was
yeah.
3 hours after I passed 2 kidney stones. And
Oh.
she says to me, she says, why aren't you in person? Your Honor, I was in Scripps Hospital passing kidney stones. Oh, you think, Maryann, she said, are you okay? How you feeling? How you feeling since you? I hope you're okay. I hope you feel better, Miss Fishman. Judge
Mm-mm.
Schauer doesn't know how to say that.
Oh.
She's a monster.
Oh, yeah.
She doesn't know how to say that. Doesn't know how to say that. How do you wear a robe?
Monsters
How do
are
you how
real.
do you pass the bar? How do you become an attorney? You're not a human being. You're a
No.
disability discriminator, and you hide behind sovereign immunity. But guess what? Sovereign immunity is allowing you to hire. You're fired December 31, 35. You're 20 end of the year. You're terminated. You don't like it. Hey, you know your career is going to be remembered by how you discriminated against loads of disabled people, not just me.
And
And your career is going to be remembered for shame and breaking apart families and hurting kids and hurting my autistic disabled son, hurting disabled kin of mine. And that is not something that we're going to celebrate. That's something that you'll be admonished for. And we'll see. You never know. You got presidents that have balls like Donald Trump. Amen to him. Maybe he'll sue more of these judges. You
and
know,
God,
it's a shame.
yeah.
But you know what? How else you going to call them out? Sue them. Make them defend how they have immunity
Hmm.
for discriminating against disabled people. Why not? Hey, look, you know,
And they don't realize God is watching. They ask us to swear on a Bible. Well, they've got to, they're going to answer to God.
you said it. My kids are almost 18. I hope to see them one day. Suppose these order protections end September 10th. Um, you know, order protection for what? I'm a disabled
Yeah.
person. You know, I have an aide, I have a driver. Okay, I go to hospitals, I go to rehab. I have stimulators that have been replaced 3 times, open surgery. I've had infections. Why have an order protection to begin with? Well, that's your
Right.
weapon. That's your weapon to try to, throw someone in jail. Why are you
Right.
throwing a disabled person in jail? It costs a lot. The counties put someone in jail.
Right. So it's
Governments are having to rethink putting people in jail. To say, Maryann, it costs a lot of money. 2 or 3 thousand a day. I read Westchester
oh,
County to house a disabled person with round the clock nurses. Keep in mind, the nurse saw I was gagging. She came in with water. Didn't matter. It was 3 a.m. I mean, every 3 hours they're taking blood pressure. They don't give a crap about sleeping. Sleeping in the jail, screw you. Feed food? Oh, who cares? Your food's been sitting out 3 hours. You got no fork? Yeah, I got no fork and spoon. So what? Eat with those fingers. Well, I'm just not going to eat. You know. So it's
Oh,
like you're forcing medical care. It's not even good medical care, right?
right.
And you're housing all these people. And let's talk about wrongful convictions, right? The recidivism rate after 55 drops to like under 2.5% in the country. So why are you housing people over 55? Why? Raped, stab someone. What is the purpose? I got a better idea. Take away all their money. Someone try to take away all their money. And people might be more valuable that they lose all their money and they won't commit a crime than, you think they're going to be in jail. Because keep in mind, if they're disabled, how many times has that disgusting excuse for human being Harvey Weinstein gone to the hospital?
Mm.
Maryann, Harvey Weinstein's not paying to go to the hospital. New Yorkers and Californians are. They're the taxpayers. You're paying for him to go to the hospital like every month? Like what? What do you take away all his money? I mean, what is crime? What is this? Isn't crime. This is vengeance.
Oh, it is. Yes. Yes.
And let's call out District Attorney Susan Kachesi,
Oh, yeah.
okay, in Westchester. She has a Facebook page, Susan Kachesi. Look her up, viewers. Right? She talks about domestic violence survivors. She talks about honoring the police, honoring Italians. She talks about honoring Holocaust victims. That is all good and recognition, and we thank you for recognizing all those groups. You don't celebrate International Disability Day. You don't do anything to accommodate 40% of your prisoners in Westchester County Jail are disabled. You oppose accommodations. You don't even have an American with Disabilities liaison. On the Title II of the ADA, every government entity, she's a government entity in New York, state government, 284 employees. Every government entity must have an ADA liaison. You don't even have one because you don't care about disabled. You don't care about being accommodated. You don't care they don't hear. Let's call you out. You are a disability discriminating district attorney. You don't care about disabled people. You don't care about the fact I couldn't hear during the trial. You don't
Mm.
care about the fact that I had a disability aide who said I didn't commit a crime. You don't care about the fact that my supervisor said I didn't commit a crime. You don't care about the fact that my cop, who has a pattern of discriminating against disabled people, 3 of the 5 instances that he was fired for misconduct were against disabled people. You don't care about that. All you care about is protecting the other judges and protecting your conviction. My ex-wife's favorite, so I'll never see my kids again. You don't care about justice. You don't care about disabled people. You have no empathy. You hate disabled people. You think disabled people are convicts, aliens, and should be punished. You are unfit for office, and the governor should remove you. The governor should remove you because
Mhm.
you cannot be taught disability accommodation. We've tried to for years. You, your predecessor, DA Roker, DA Scarpino, we have tried to. And the fact that you continue this fight against me and others, when I was in jail for my 2 weeks, the warden asked me to write accommodation requests for others because he saw how much I was advocating for myself and others advocating for me. And I couldn't believe it. And he asked why. I said, warden, I have nothing to do. I'll do what you want. But why don't you have your sister do it? Why don't you have the staff do it? Why don't you do it? He said, Mr. Fishman, we're afraid. So what are you afraid of? We'll get fired. If we
Mm.
advocate that the person who can't hear needs a deaf interpreter, I'll get fired. I'll say it's too much money. If we advocate that, the person has a muscular problem and can't have bowel movements on their own, we'll get fired. But I'm looking at you. You have disability advocates coming. You have people writing letters. You got people visiting you every day. You got Donna Drum coming to the jail, see if you're okay. You got the county ADA liaison writing. I mean, obviously with you, they want to help you. So maybe we can use some of the notoriety and publicity of helping you to help others. You know what? I wrote a lot of accommodations, and I fought to get 2 of my friends out of jail who were also disabled,
Mm.
after I got out because you know what, Maryann? It's a duty of society. I have a privilege to open up my big Jewish mouth
Yeah.
and my fat chin, okay, with the battery on the left, the battery on the right, and the wires in the oven and everything. It's a privilege. I'm alive, and I say this to you and the
Yes.
other publicists and other journalists and other advocates. It's a privilege. I'm talking to you. You're not only a beautiful woman, a great advocate, an
Oh, thank
amazing
you.
host, all the above. But listen, under every medical standard, I should be dead. I should be dead.
Yeah.
I should have had a stroke. I should have had an aneurysm. I should have died from sipping water. I should have had a drug overdose with all the Lyrica at almost 400 milligrams a day.
Oh,
I mean, you
yeah.
should have overdosed with cyclobenzaprine. Should be dead with the gabapentin. Should be dead with the oxycodone, the hydromorphone, the oxycontin. I mean, my liver's at 600. It's a miracle I'm alive. So now that
Hmm.
I'm here with my 45-day jail sentence and warrant, okay, to go to jail for not committing a crime, where you fired the cop, where we have the video saying I didn't commit one. Now that I'm here, that I live on my pain, I can't sleep, I can't see my kids. You
Mm.
take away my retirement account, you take away my ability to work a normal job. You know what? I'm here to open up my big mouth with my friend Maryann and other journalists to tell you, you know what? Judge Schauer, you can run, you can't hide, you're going to get fired, you're going to get terminated. Maybe they'll pass a law to take away your pension. I don't know. They got to teach you somehow to have empathy and care for other people. And maybe, you know what, you'll just get away with it in your own mind and think, oh, you jailed Fishman. Oh, he had warrants for all these years. Oh, he's a convict. Oh, he's a fugitive. Judge Schauer, no one cares about any of that. They just cared about the fact that you attack disabled people. And the fact that I have to come on TV and podcast to call you out at disability discriminating, Judge. To call you out because you are a disability bigot. You hate
Oh,
disabled
yeah.
people. And
Yeah.
some of your associates hate it. And your other judges think they're doing a service by protecting you or protecting other
Ew.
judges who make me fight to get real-time transcription. Maryann, fight for a note taker, fight to go on TV, fight to get an op-ed, fight to do this. Maryann, as I said, I love you. I should be dead. So since I'm here and I can't see my kids and hug them, I might as well help you hug your kids and the other people and call the disability discriminators out.
Mhm.
Retaliation on the ADA is illegal, but you guys just retaliate. And when we try to appeal, most of the time, you appellate courts in New York say we don't have permission to appeal. The ADA doesn't have a requirement that to dispute the denial of an accommodation that you give permission. You're supposed to have the interactive session to explain why you can't give them the accommodation and whether it's reasonable or not, and whether I'm qualified, acknowledged, and designated disabled. And I'm happy to tell you my most recent federal appeal, 25-423, Fishman versus New Rochelle, and Officer Lanes last year. Guess what? Judge Rahman ruled I'm disabled. And Judge Rahman ruled that he heard me ask the accommodation 3 times on camera. And Judge Rahman ruled that I'm disabled. And he said New Rochelle didn't even oppose that he's disabled for 6.5 years litigation. So now we're asking the appeals court to send the case back that was dismissed and say, give me my trial, give a jury determination on whether the accommodation was reasonable, okay, or not, and what the damages should be under the Rehabilitation Act for you taking federal funds and intentionally discriminating against a disabled person with a 30-page order from Judge Schauer. A 30-page visitation order for what, Maryann? There's only one reason. Because obviously anyone is going to fail at a 30-page order, let alone a person with short-term memory in 2016 and 2018 by a neuropsychologist at 4%. 4% memory compared to other 44-year-olds. 4%, another report, 6%. The maximum I've been is 8%. So 4 to 8% memory of other people my age. You fault me for not remembering. You think I'm going to remember your 30 pages, and you don't want to let my aide explain it? You just want to arrest me because the ex-wife says, arrest me? Matter of fact, we have her video. We have her audio where she says, don't arrest him. But somehow I get arrested. Don't arrest him. She says, I just want to note it for family court. And yet she doesn't get prosecuted for a misdemeanor or felony for violating a false arrest report. And last year, no charges for putting in a false arrest report. So last year put down that I was arrested for violating a duly executed order of protection. But the third
Oh.
page says I wasn't served. So it's not a duly order. It wasn't given to me in a way I could understand it. It wasn't communicated to me in a way I could understand it. And when we had our hearing to get the accommodation, Maryann, for the July 1621 order, Judge Jacob, who used to be the chief judge in the Federal Second Circuit, he said in response to my attorney, he said, Mr. Fishman cannot be guilty of violating an order, a court order that wasn't explained to him in a way he can understand it. Again, let me repeat that for yours. Mr. Fishman cannot be guilty of violating a state order that wasn't given to him or communicated to him in a way he could understand it. Maryann, it was an oral order which someone doesn't hear, someone doesn't register, and no taker's denied access. The ADA advocate doesn't hear it. I don't hear it. My attorney doesn't hear it, but it's somehow given to my ex-wife. When the cops at it. But when we have our jury trial, only 2-page order of protection given to the jury. But the order of protection 3 pages, because you know what third page said? Party not served. And so as we got more and more federal orders, more and more federal discovery, we disclosed it, and they kept on saying conviction stand, conviction stand, conviction stand. They will protect the state of New York, County of Westchester, City of New Rochelle, will protect their judges at all costs. Because once we prove, and we will, through publicity or federal court, the mafia of the government, the mafia and the organized conspiracy, the RICO, the organized disability discriminators, working all together to deny accommodations, like you said, there's no way to repair these people. They all got to be fired.
Mm-hmm.
Give us new judges. Give us new judges.
Yeah.
And I'm ashamed to tell your audience, Judge Conatero, a couple weeks ago, denied me permission to appeal my denied accommodations in this criminal case. He said it's not appealable order. You know what I said? I then asked for his recusal. He says, "Oh, we can't recuse under permission requests. So the only way a court of appeals in New York hears a criminal case is through permission request. But your permission is denied because it's not a final order on New York State Constitution." Maryann, I'm not the smartest, but I have a big Jewish mouth, and I got two batteries that rev me up, and I'm here talking to you, and I love speaking to you. I love going to your show. Maryann, the American Disabilities Act and New York State Human Rights Law and S5533B don't say anywhere. And I need permission to challenge the denial of an accommodation in the state court, even the state criminal court. So, Your Honor, the law doesn't say that. Oh, but it's you, Fishman. Screw you. You ain't going to win ever. You know what? Just by going on this podcast and telling other people not to suffer, like Mary and I suffered going to jail for crimes we didn't commit, we win. And future kids will win. And you disability discriminators, you're going to go and you have to answer to God one day. And you got to deal with the mirror. Right, Maryann?
Definitely.
Yeah, deal with consequences.
Oh, I'm so glad you came on. And how else can people reach you other than at protectnewyorkers.com?
Sure. So we also have NewRochellePoliceAbuse.com, NewRochellePoliceAbuse.com. So that is where we update on the status of the case in federal court and the status of the case to cops. We are still in the federal Second Circuit appealing this case where the judge said that whether I got the accommodation or not wouldn't matter. It does matter.
Oh,
if you
yes.
got meaningful and effective communication, then you wouldn't have been arrested. And if it came out, obviously, that the cop never read the order he's arresting me for, then it comes out. And by the way, my case is caught up with times. So when the Court of Appeals took Harvey Weinstein's case, a known female serial rapist, right, took his case, they said bad acts can't be used against the defendant in court. Bad acts can't be used, previous bad acts, right? Obviously, he's a pattern rapist, pattern ugly person, not defending him. But they said in his case, his previous acts, which he was never charged for, never convicted of a crime for, can't be used against him. And since you did that, we reversed his conviction. Well, in my case, they told the jury that I previously violated the order of protection from my mother sending gifts, my aunt sending gifts, and my daughter ordering on the Amazon with the gift card I gave her 2 years before the order of protection was a previous bad act. They told the jury it was a bad act. They told us bad act, so he's a priest. That couldn't be mentioned. Mentioned what? My daughter ordered bras? My daughter ordered an appliance from her disabled brother? My daughter ordered stuff for her desk? And I'm faulted? How dare you give her $1,000? And you didn't do this other report. How many reports you want me to do, Judge Schauer? We've done 19. Oh, but I'm going to throw you in jail because you didn't do the 20th evaluation. Your Honor, excessive review of disabilities and discrimination. I'm disabled.
Yeah.
No, Ms. Fisher, just don't follow orders. So what I'm saying to you, Mary, and others is that we have to educate and we have to tell our stories over and over again and tell us that there is a carve out, that there is no immunity. And unfortunately, some of us suffer. I love you, Joanna, Jonah. Jonah just turned 20. I miss you, son. I would love to contact you, but I'm told I'll get arrested and charged with a felony if I attempt to. I love you, Joanna. Congratulations for graduating Binghamton early. You're amazing. You're lovely kids. You're the best a dad could wish for. And I only want to be a father to you. I'm not allowed to be. And Sky and Aiden, I love you. Aiden, I think you're a great reader. You're a great, great jogger and a great person. And Sky, I'm so proud that I was able to help you go to your conference in Anaheim, and your future business leaders America. But when I helped him, then my ex-wife files papers saying I'm harassing, so they terminated access to school records. And, I filed an appeal, Maryann, in June. The appellate court in Brooklyn, the same appellate court that was overruled by the federal court to grant the accommodation that the federal Second Circuit ordered, that Brooklyn Appeals Court, appellate division second department said you're not disabled. But federal Second Circuit ordered, hired them, right? The Brooklyn Appeals Court on motion that normally gets heard in 2 to 4 weeks. It's been 6 months, Maryann. They haven't given me a decision. Well, you got to wait till Judge Schauer's fired? What decision? Under FERPA, FERPA, you can't deny records to a parent. I never called the school. I never spoke to his teachers. I never visited the school while they've been there.
Yeah,
right?
Exactly.
But I'm denied access to school records, and the appellate division as retaliation won't give me a decision. This is disgrace, it's embarrassing retaliation. You just want to hurt me and my kids. But we'll call you out for it.
Yeah.
We'll call you out for it because, retaliation is legal, and those of us with disabilities, we get retaliated more than anybody else. And we got to fight. We got to fight. We got to fight for the civil rights. We have to clean house, get new judges, and have to put in safeguards and, have to stop
and
the disability
keep
discrimination. So thank you
speaking
so
out
much
and keep
for this
speaking
forum.
out.
And
Yeah.
protect New Yorkers.
Yeah.
ProtectNewYorkers.com. Please register. We do believe that anyone with a wrongful conviction from a cop, or anyone who was convicted and wasn't told that their cop was a pattern misconduct cop, like Lane Schlesinger in my case. Okay, in New York, you're required to get all the background on anyone who testifies against you. Lane Schlesinger was the only cop testified against me. Lane testified I didn't go on the property. How do you guilty of actually committing order protection
Yeah,
for
I
unserved
know.
order with no
Yeah.
distance, stay away from the property during supervised visit? Okay, how? You can't be. Oh, but you're Marc Fishman and you sued Judge Schauer.
That's
And the
why.
marshals went to her mansion on overlooking the Hudson River. So you're guilty till you're dead. No, Judge Schauer, you're fired, and you are lack empathy, and you're a disability discriminating judge. Shame on you, Judge Greenwald. Shame on you, Judge Oliver Gordon. Shame on you, Marie D'Ambrosio. Shame on you, Carol Jordan, magistrate judge. Shame on all of you that discriminate and hurt the most vulnerable disabled. Shame on you for taking away our kids. All of you
Yes.
need to be fired. And new judges need training and education so that you can have empathy towards disabled and disabled veterans and accommodate us, not punish us for our
Right.
disabilities.
Right. Hey, Mark, don't jump off. Slam the Gavels, a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Maryann Petri. You can find me on Spotify, YouTube. Please like and subscribe, Apple iTunes, iHeartRadio, Google, other platforms. Again, feel free to buy me a coffee to help keep this podcast going. Thank you, Marc Fishman. Always a
Thank you,
pleasure, and I've
Maryann.
learned more. Thank you.
Thank you. Continue opposite. And guys, keep advocating and keep fighting for your kids. It matters.
Oh, it
It
does.
matters.